Hi everyone, I'm Rocio de la Cruz, Principal Associate leading global data protection projects at the firm. I'm sorry I cannot be with you in person, and I hope you all are keeping yourself safe. In this session, I will cover the impact of Brexit on your data protection compliance routine. And let's start by having a look at the law that applies during and after transition period. So during the transition period, everything remains the same. Therefore, the European laws will apply as it has been stated in the Withdrawal Act 2018, and you don't need to look at any changes during this transition period. However, after the transition period, we will have a legal regime in the UK that mirrors GDPR, and we will refer to this regime as the UK GDPR. And in short, it means that the GDPR rules will be part of the UK law, and this is stated in the Data Protection EU exit regulations. Now, in addition to the UK GDPR, the GDPR might also apply, because remember that the GDPR has an extraterritorial effect, which means that some of you may need to consider the application of both the UK GDPR and the GDPR. And then in terms of other applicable legislation, the Privacy and Electronic Communication Regulations, PERC, which, as you know, this covers marketing, cookies, and electronic communications, will still apply since it is already UK law. And the same happens with the NIS regulations that covers network and information systems, and it is also UK law, and it will apply as usual. However, the eIDAS regulation, which affects trust service providers, will not longer apply in the UK after the end of the transition period, but the UK government is taking steps to incorporate these rules into the UK law before the end of the transition period. So coming back to the UK GDPR and the GDPR, Brexit will practically not affect your data protection compliance plan if your company is based in the UK only, and it only sells to UK individuals, and either it does not monitor individuals, or if it does it only concerns individuals who are in the UK only. And also, if the data processing activities are not subject to international transfers of data. So in these cases, nothing changes for you. You need to look at other Brexit implications on your business, but definitely not on the data protection side. So what to watch out for then? So the most important thing, I think, it is international transfers. And this is the first thing I recommend to look at. So review your international data flows within your company and identify data, in particular data coming from the EEA to the UK. And I think this is relevant because after transition period, the UK will be considered a third country for the purposes of data protection. And although the DCMS published a few days ago, on 13th of March, an explanatory framework for adequacy decision, which means that the UK is seeking adequacy decisions from the European Commission, this process takes long, and I would actually not count with being an adequate country by the end of this year. So as you can see in this table, any data going to the EEA from the UK is not a restricted transfer, so that's fine. And the transfers to focus on are those coming from the EEA to the UK. And these are the common questions we've got from many clients concerning the international transfer of data. And the main one concerns data processors sending data to the UK company they work for. So that would be when you have a data processor who is based in the EEA and needs to send you personal data to the UK company. And the main issue is that there are no standard contractual clauses approved to cover a scenario in which the processor is the exporter and the controller is the importer. And it is normally the controller, the one sending data out, to the processor or to any other third party. So in these cases, there might be a chance for you to rely on one of the Article 49 exceptions. And the clear example is to cover an one-off transfer of the data back to the controller when the contract with the processor terminates. However, this is a narrowed exception, and it is subject to a compelling legitimate interest balancing test that you need to carry out. So it's the same that when you carry out the legitimate interest test for the Article 6 legal basis, but this needs to be like compelling legitimate interest, which needs to override the rights and freedoms of the individuals. Subject to this test, also there are other requirements to rely on this exception. One of them is that the ICO needs to be notified of the transfer. So you need to keep records of the procedure you have followed and the decision taken, because the ICO will probably ask you for information once you notify them of your intention of transfer this data or to receive this data from the processor. And the other option, and also for ongoing transfers of personal data, is if none of these exceptions are suitable or convenient, is to put in place the controller to processor standard contractual clauses. So if the processor is not a third party, you have an additional option, which is putting in place binding corporate rules within your group, within the company group. But coming back to a situation in which the processor is a third party, then this other option would be putting in place controller to processor standard contractual clauses. Now, in the controller to processor standard contractual clauses, the processor is the importer, and then you will need to implement the same rules for the processor being the exporter. And the way to do this, in our opinion, is by adding commercial clauses in Annex B to the standard contractual clauses to cover this situation. So something very important that you need to remember and bear in mind is that that's the only amendment allowed for the standard contractual clauses to be a valid mechanism to transfer the data internationally. So it is very important that when you do the amendment, it's not an amendment, it is an addition to this Annex B, and that you consider this inclusion as commercial clauses for the data processor to commit themselves to follow exactly the same rules, and respect these safeguards when it is transferring data back to the controller from the EEA to the UK. Moving on to another query that has been discussed with clients during the last months is what happens to those entities who are Privacy Shield certified to whom we are sending data from the UK. So this is the only scenario that we have discussed with clients in which UK data is going out to a third country. And this is because the Privacy Shield covers data sent from the EEA, but the Privacy Shield does not cover data sent from the UK, considering that the UK is not part of the European Union anymore. And in these cases, the Privacy Shield certified company should commit to comply with the scheme for the data sent from the UK to the States as well. Or the other option is, again, to put in place standard contractual clauses, since this is no hesitation of valid mechanism to export UK data to third countries. So that might be a preferred option at the moment. Interestingly, but this is in a very early stage, the ICO has published detailed guidance on the codes of conduct and certification schemes. So this is something that I recommend you all to check it out, to see whether your company would be willing to apply for one of these certification schemes when there are further developments on this area, and also to have a code of conduct approved. But coming back, what's relevant from a Brexit perspective, I mentioned before that you may be subject to the UK GDPR and the GDPR as well. And this may happen if the UK company you work for has branches in European locations, or if it offers goods or services to individuals who are in Europe, or again, if it monitors individuals while these individuals are in Europe. So the main consequence is that the UK entity will need to appoint a representative in the European Union and to consider who the lead supervisory authority will be. Also, just a little note to remind the fact that the UK Data Protection Act has also extraterritorial effect despite Brexit. So there might be other European companies to whom the UK Data Protection Act applies. But coming back to our scenario in the UK, being subject to the European GDPR and the UK GDPR, the main thing that clients are considering now is who their representative will be. So in terms of appointing the representative, it's a written appointment. And we recommend considering the locations with a greater level of decision-making on the processing of personal data by your company. Not only in terms of the representative, but also in terms of deciding who would be the lead supervisory authority if you need to deal with an international cross-border data breach. Since you will be subject to the ICO and the EU regulators' enforcement actions, you may need to update your data protection policies accordingly as well, and in particular the rules concerning breaches of data and the handling of data subject complaints as well. So to finalize, just a recap of the main steps to follow to get ready for Brexit situation. And the most important thing, like I said, is reviewing the international data flows. Check out the ICO and the European Data Protection Board guidance documents that we are having some development now, which, by the way, we are planning to do a webinar soon in which we will provide an update on recent developments in the data protection field. And also considering putting in place the intergroup agreements or standard contractual clauses with third parties, and check out the codes of conduct and certification schemes in case that's of your interest, and consider whether GDPR applies to your company in addition to the UK GDPR. So this is all I wanted to cover in this session. You can see here my contact details, and please feel free to drop me a line if you have any queries. I hope you found this session useful, and have a lovely day. Keep yourself safe, and hopefully we'll see you soon. Thank you. Goodbye.